It's 8 o'clock. Senate Committee on Criminal Justice come to order. Clerk, call the roll.
Chair Flores,
Aye, here. Gee, I'm already got my eyes.
Vice Chair Parker, Senator Hinojosa,
Present.
Senator Huffman, Senator Miles,
Present.
Senator King, Senator Hagenboom.
Quorum is present. Has been established. Our agenda this morning contains two important remaining elements of enacting bail reform in Texas, Senate Bill 3073 and Senate Joint Resolution 87. So Vice Chairman Parker was present. A majority of law-abiding Texas want violent criminals, murderers, serial rapists, and child molesters, among other dangerous felons, are held in jail and not released to claim new victims. Let's help make this happen. It's the intent of the chair to lay out the bills one at a time, take the invited public testimony, and vote each bill in the order of presentation. If you intend to provide verbal testimony or would like to register a position in one or more bills, please register at one of the kiosks located behind the committee hearing room. Chair lays out SJR 87 and recognizes Senator Huffman to explain the bill.
Thank you. That on. Thank you, Mr. Chairman and members. This is another
It's a
constitutional amendment that addresses the critical, thank you, bail issue that we have throughout the state. The House is still making good progress on what we have already sent over there, and I'm very optimistic that those bills are still, and constitutional amendments are still moving through the process. There's no indication that they're not. Well, we hope that everything is fine, let's put it that way, but it looks good. This is just will be another tool in the toolbox for judges, and this will be a bail denial for repeat offenders. And as you know, back in 2019, when we started making some of the jail reforms, we started, gathering more data. And through that data, we start to get a bigger picture of like the crime and what's happening throughout the state. Once I started looking at some recent data that came in, that I started studying, just to study the offenses are murder, capital murder, different types of capital murder, aggravated kidnapping, indecency with a child, aggravated assault of deadly weapon, and there's all kind of forms, aggravated sexual assault, and aggravated robbery. So those are just the most serious of the serious crimes. In the year 2024 in Texas, this is statewide, there were 30,764 people processed just for those offenses that went through the public safety report. So the PSR report, that's where we get this information. And then we dug a little deeper into bonds and the amount that were granted. And, even on murder, there were 1,000 people in the state of Texas on bond for murder. There were 1,500 for indecency with a child, 16,000 for aggravated assault with a deadly weapon, aggravated robbery, 3,857. These are the ones that got bond. So when you start looking at those numbers, it makes you realize that we need to ensure that the public, that the judges has a tool that will keep Texans safe. So what this joint resolution does, if approved by Texas voters, it amends the Constitution to require the denial of bail to persons accused of certain offenses punishable as a felony. And they are basically the ones that I just laid out, but also trafficking or continuous trafficking of a person. And what it says, if you have been either convicted of one of those or you are currently on bond for one of those most serious offenses, and you commit, or there's probable cause to believe that you committed another one of those same crimes. So you're on bond for murder, or you've been convicted of murder, and there's probable cause found that you have committed another murder. Or you're on bond for aggravated robbery, or you're convicted of aggravated robbery, and there's probable cause to believe that you've committed a murder, then you must be held at no bond. So there is no judicial discretion at that point. Those are very unique situations, the most serious of the most serious offenses. And as I said, the bills moving through the House are great. They give the judges discretion. They are, again, just for the most serious offenses, but this will cover when we have these repeat offenders. And, I know there are people probably listening and think, oh, that never happens, but it actually does happen. And Senator Miles, in Harris County, you've seen the news. We have seen instances of even individuals who are out on bond for like 6 or 7 aggravated robberies. I mean, and so this bill, this constitutional amendment is meant to address those very specific instances. And I'm happy to answer any questions.
Senator Hinojosa.
Thank you, Mr. Chairman. And I guess what we're doing with this SGR 87 is trying to target the most serious crimes, violent crimes that are being committed against our families and our community.
That's correct. And even though the bill's moving through, they're also just for violent offenders. I don't want anyone to think that it's for all offenders. These are violent offenders. But these are for the repeat offenders or the previously convicted offenders for that very, very strict set of offenses, violent offenses.
So if someone has been previously convicted of, let's say, murder,
Yes.
And that person is out again,
Yes.
and recommit or commits another offense of murder, or one of the listed here in,
Yes.
in SGR 87, then that person could be denied a bond.
Yes, once probable cause is found, so the judge has to believe there's probable cause to believe that that the individual committed the offense, then the judge shall deny bond. So there's no question on what the judge's role is in that. So we're going to let the legislature set that, and the people of Texas make that determination. And again, once I started looking at these numbers and really started digging in, and we hear stories, we talk to victims, we see what's happening in the news, but the numbers are facts, and as the years go by, we'll have more and more data as this accumulates. So.
And as you read those numbers, it seems to me that even though judges know that the person in front of them had been previously convicted of murder, they still let him out on bond. And even some who've been out on bond, who committed a violent offense listed in SGR 87, even again provided bond. We've seen that again and again,
Right.
not only in Harris County, but in other communities in the state of Texas.
Exactly. And this gives, some judges we've heard from some judges who've wanted to do this, but felt like the law tied their hands and they had to set something. And this relieves them of that issue as well, where you see like $5 million bonds or $1 million bonds. So that it kind of relieves that pressure upon the judiciary as well, so that they say, this is what the legislature wants, this is what the people of Texas wants, and so that's what we'll do.
Thank you for answering my questions.
Any other questions? Senator Miles.
In Section 2 of this bill, Senator, you're bringing this to the people, the voters, is that correct?
Yes, sir.
You're bringing this to the voters, is that
Yes,
correct?
sir.
Okay.
Yep.
And they'll make the final decision.
They will make the final decision if and I think the ballot language is quite clear about what we're trying to do here. Yep.
I think,
I like to write ballot language so that the voters really understand what they're voting for.
yes,
I mean, I'd really try to write clear ballot language.
plain and simple.
Plain and simple, yes.
Thank you.
Yes, sir.
Thank you, Madam Chair. Any other questions from members? So at this point, Chair will now call invited witnesses for SJR 87. And I see no one registered, so with that, we're closed for invited witnesses. Chair now opens for public testimony. Chair calls Nick Hudson. Nick Hudson. Good morning. It'll be your name, who you represent, and you have a position on the bill, and you have 2 minutes.
Good morning, members. My name is Nick Hudson. I'm here on behalf of the ACLU of Texas in opposition to SGR 87 respectfully, which requires detention without due process for certain serious allegations. And I want to acknowledge that these are certain serious, rare cases. The right to be free before trial is deeply rooted in our history and legal traditions in Texas and the United States. Texas founding documents speak to liberty as its highest ideal. In its Declaration of Independence from Mexico, the founders of Texas condemned the unjust incarceration of its citizens. As the Supreme Court has recognized, freedom from bodily restraint has always been at the core of liberty, protected by the Due Process Clause from arbitrary governmental action. This right is especially important when the presumption of innocence applies. It is, as the court put it, that bedrock, axiomatic, and elementary principle whose enforcement lies at the foundation of the administration of our criminal law. And the Supreme Court held, because of all these things, that in our society, liberty is the norm, and detention prior to trial is the carefully limited exception. And what that has traditionally required is something beyond an allegation. What it has traditionally required in the U.S. v. Salerno case is a showing by clear and convincing evidence in individualized hearings based on individualized facts and circumstances that an individual poses an unmanageable risk to safety or to flee the jurisdiction. This SJR 87 sort of turns the presumption of innocence on its head for these, again, certain serious allegations. It mandates detention without due process. The last thing I want to say, when I think about mandatory detention, I think about some of the people who have been wrongfully accused and some of our exonerees in Texas. We have the most of any state in the country. I think of people like Michael Morton and Anthony Graves. And so as we're thinking about these sorts of circumstances, I just ask that we maintain judicial discretion in these types of cases. Thank you.
Thank you for your testimony. Chair calls Kirsten Budwine. Thank you. Just for the record, and of course we know who we think. Good morning, and your name, who you represent, your position on the bill. You have 2 minutes.
Good morning. Kirsten Budwine, policy attorney with the Texas Civil Rights Project in opposition to this SJR. I'll keep my testimony short and sweet. Earlier this session, I, along with many other advocates, testified against 2 similar constitutional amendments, SJR 1 and SJR 5, both of which were voted out of the House Criminal Jurisprudence Committee not even 48 hours ago, and will likely be heard on the House floor by the end of this week. It is on the heels of this fact that I am confused and disturbed by the introduction of yet another constitutional amendment that doubles down on stripping the discretion away from judges and the unconstitutional practice of automatically denying bail without an individualized assessment of risk. The bail package that has already been negotiated will overhaul the entire bail system in a way that will be felt for generations to come. This constitutional amendment adds insult to injury, and with that, we oppose this SJR. Thank you.
Thank you for your testimony. Any questions, members? Thank you very much. Show Senator Hagenbu as present. I see no one else registered for public testimony. Is there anyone else who wishes to testify on, for, or against SJR 87? Hearing none, public testimony is closed. Chair moves that SJR 87 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Senator Flores, just real second before we vote, because I misspoke briefly to Senator Miles, and I want so that we are going to change the ballot language. I forgot we had a floor amendment, but it actually makes it clearer to your concern. So it even makes it simpler to understand. But I didn't want to say that this was it when I'm going to change it on the floor. Okay, but I promise you, it's very similar, just clearer. Yeah, it's very simple. Thank you, Mr. Flores.
Thank you. Chair moves that SJR 87 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores.
Aye.
Vice Chair Parker.
Aye.
Senator Hinojosa.
Aye.
Senator Huffman.
Aye.
Senator Miles.
Miles votes yes to bring people of Texas.
Senator King.
Aye.
Senator Hagenbu.
Aye.
7 ayes, no nays.
7 ayes, 0 nays. SJR 87 will be reported to the full Senate with a favorable recommendation, and it will go to the floor. Chair lays out SB 3073 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. As SB 9, which was the cleanup bail bill that has moved through the House, it's been determined that a piece of it is not going to be germane under the House rules. So this is a separate little bill that I'm going to rush over to the House, which was part of the original package in SB 9. And it's based on that my office has received reports that magistrates have been indiscriminately making no probable cause determinations when the facts suggest that there is clearly probable cause to warrant an arrest. Again, most of our judges are great. This is some instances where this has happened. Senate Bill 3073 requires a magistrate who determines that no probable cause exists to believe that a person committed an offense in which they were arrested to enter in the record written findings to support that determination. And that's it. It's very simple. If they're going to deny a probable cause, they just put it in writing. Again, it doesn't affect their discretion to do so, but It gives the prosecutor direction, or police in many instances, what it was that, caused the judge to believe that they couldn't proceed further. That's it. Thank you.
Members, any questions? Any questions, members? If not, the chair now opens up for invited testimony. I see no one had registered for invited testimony, so invited testimony is closed. Chair now opens for public testimony. I see no one registered for public testimony. Is there anyone wishing to testify on, for, or against Senate Bill 3073? Hearing none, public testimony is closed. Chair moves that Senate Bill 3073 be reported to the full Senate with a recommendation that do pass favorably and be printed. The clerk will call the roll.
Chair Flores,
Aye.
Vice Chair Parker,
Aye.
Senator Hinojosa,
Aye.
Senator Huffman,
Aye.
Senator Miles,
Nay.
Senator King,
Aye.
Senator Hagenbu.
Aye.
6 ayes, 1 nay.
There be 6 ayes, 1 nay. Senate Bill 3073 will be reported to the full Senate with a favorable recommendation. Chair now shall calls up the matter of pending business. The chair lays out Senate Bill 781. Members, are there any questions to Senator King? 781,
Yeah,
Senator King.
be happy to kind of walk through it again. Members, this is a bill we heard previously, and I really appreciated the dialogue and testimony about it. Actually, we were going to wait for the House bill to come over, but it died an untimely death a couple of days ago on a point of order that was unrelated to the substance of the bill, and so we're trying to move the Senate bill over there for him. If you remember, this dealt with the file management for law enforcement. There was a TCOL work group that met for a long period of time, both made up of law enforcement and non-law enforcement personnel. They came up with a model policy. The policy is already in effect voluntarily in governing over 20,000 officers' files in Texas. Every city that's under state civil service, it's a matter of law with them already. That would include Fort Worth, Plano, Corpus Christi, Wichita Falls, and Austin, Waco, Lubbock, Amarillo, Houston, and a host of other cities that are already under this. This just makes it consistent across the state in how those policies are handled. This version of the bill passed out of Homeland Security in the House 10-0, and again, it was on the calendar, and when it got to the floor, it just got bumped by a point of order, and so we're just trying to move it from there. Be happy to answer any questions about it.
Senator Miles.
Thank you, Mr. Chairman. Senator King, this is the same bill that you and I discussed, that the files, if not found to be proven guilty, the files, everything's removed and they're sealed, right?
Yeah, essentially, it's you end up with, like in Houston, the way they do it today. You have two personnel files. One has all the public information that can be on an officer. The other one would contain the background information from when they were going through employment application. If they have been found to have, if they were formally disciplined for some action, that would be in the public file. If they were accused of an allegation and exonerated for that allegation, then that would be in the sealed file. So it just basically separates what's available to the public and what's not. For example, right now in many communities on an open records request or other request, you could get the officer's home address and things like that. So what's private is set up as private, and what's public is set up as public. It doesn't create any issues with any of our due process for criminal cases when they're trying to find out an officer's record. That is still discoverable under the Code of Criminal Procedure.
I understand that. But my problem still remains on this, is that those sealed files, we can't tell the propensity and the mindset and the capability of the officers, which we always thought was important. I always thought was important. And some jurors have found that that information is important as well. So for that reason, you can understand, I won't be voting for the bill. Brother.
I understand completely. I think and your point is well taken, but I think where the confusion sometimes comes in is if you were to send an open records request, a Freedom of Information Act request regarding an officer, under this, or in Houston, because it's in practice today, if they had been accused of maybe drinking on duty or of assaulting someone or improper arrest or something, and had been exonerated, then that would not be released.
That's correct.
However, if there was a criminal case and it was dealing with the officer or a Michael Morton type situation, the defense for that person could still get those files for that criminal process. And so, whereas the general public could not get those files, but if it is in a criminal court, those files would be available to the defense, and then the defense could try to build that case. Well, look, he's been or she's been accused of overreacting in situations 3 times previously, and they could that could be brought into the court at that time.
In the same tone, if we have a hot-headed officer or an officer that can't control his temper, it would go into that file, and no one would have access to that file. And when he transferred to another agency, that file wouldn't transfer with him, correct?
No, it actually could.
How could it?
Because under other legislation that we've previously set up to try to deal with passing bad officers from agency to agency, all of the
But
information.
in that file as well,
available.
if my mind hasn't left me, in that file as well, if they haven't been found to be guilty of those charges or allegations, that file is not put into that file.
I believe their full personnel record is available
Yeah.
from if an applying agency requests.
Okay.
Yes. It is confusing, and I understand the concerns.
Any further questions, Senator?
Well, last statement, police officer to police officer, we know that this is how some of our not so respectful officers slide from department to department to department because that information is not let out to them.
And I think it was Senator Huffman's legislation last session that really tried to make sure that all that information, and I used to do that. I used to do background checks. I spent a couple of years doing that at the academy, and it would frustrate me at the time. I would call another agency and I would say, hey, we've got so-and-so used to work for you. They've applied for a position with us and want to find out some questions about their background. And sometimes they had entered into an agreement, hey, if you'll resign, we'll seal your file.
Correct.
Or they would be worried about litigation or something like that. So they just would say, look, I'm sorry, our policy is we just don't release that. And it was a real problem. And I'd get around it a lot of times. I'd just start calling random officers that they'd worked with and find out what happened. But you couldn't get formal things. And so the legislation that Senator Huffman passed last session or the session before that maybe, was designed to make sure that those files were fully available to any other agency that was inquiring.
We can call for the bill.
In fact, she just informed me they're actually required to look at it. Yeah.
We can call for the vote.
Thank you. Appreciate it. Chair moves that Senate Bill 781 do not pass, but that the committee substitute for Senate Bill 781 adopted in lieu thereof be reported to the full Senate with a recommendation do pass favorably and be printed. The clerk will call the roll.
Chair Flores?
Aye.
Vice Chair Parker?
Aye.
Senator Hinojosa?
Aye.
Senator Huffman?
Aye.
Senator Miles?
Nay.
Senator King?
Aye.
Senator Hagenbu?
Aye.
6 ayes, 1 nay.
There be 6 ayes, 1 nay. Committee substitute for Senate Bill 781 will be reported to the full Senate with a favorable recommendation.
Thank you.
Members, thank you all very much for being here. That concludes the committee's business, and the committee stands in recess subject to call of the chair.